Hello friends. Today we are going to discuss about essential elements of a valid contract. There are some essential elements which are important to create a valid contract. There are elements you can see on the screen, that is offer and acceptance, intention to create legal relations, lawful consideration, capacity of parties, free consent, lawful object, certainty, possibility of performance, writing and registration, not expressly declared void. So friends, we will see these points one by one. First point is offer and acceptance. So friends, there must be an minimum two parties for the purpose of creating a contract. Friends, there must be minimum two persons or two parties to create a contract. There must be an offer by one party and acceptance by other party. Such offer must be legal and final. Listen carefully, friends. The offer must be definite, complete, and legal. It must be what? Definite, complete, and legal. It must not be vague or illusory. The offer must give rise to the legal relations. An offer on acceptance becomes a promise. Friends, second point is intention to create legal relations. Parties to the agreement must intend to bind each other through legal relationship. The agreement of a social or domestic nature are not aimed at creating legal relationship among the parties. Friends, there are some examples about intention to create legal relations. Agreement between buyer and seller do intend to create legal relations between them, and intention to create legal relations are not included. These examples are the husband and wife between two friends regarding dinner on a particular date and time, also going for a casual walk, etc., are not treated as enforceable by law. So, if you create a valid contract, you must have to intention to create a legal relationship among them. Friends, third point is lawful consideration. Friends, consideration means the price paid by one party to the other party for fulfilling the promise obligation. So, the consideration means what? Consideration means price paid by one party to other party for fulfilling the promised obligation. The price or consideration must be lawful. It must be lawful. Consideration is an essential for creating a contract. If you creating a contract, there must be a consideration. The court will not enforce a contract if it is not supported by consideration. If the consideration is not there in a contract, the court will not be enforced a contract. A bare promise is not binding and cannot be enforced. Consideration must be legal and must not be unlawful. Friends, next and fourth point is capacity of parties. The parties to the contract should be competent to contract According to section 11 of the Act, every person is competent to contract who is of the age of majority, who is of sound mind, and not disqualified from contracting any law to which he is subject. The person must be major. He should not be under the age of 18 years. He must be of sound mind. It means an insane or lunatic cannot enter a contract. His agreement will be void. A minor is not competent to any contract. Fifth point is free consent. Friends, according to section 13 of the Act, two or more persons means minimum two parties, two or more persons are said to consent when they agree upon the same thing in the same sense. If the persons agree on the same thing in the same sense, it can be a consent. And the consent must be free consent. So, section 14 provides that the consent is free consent when it is not caused by the coercion, undue influence, fraud, misrepresentation, and by mistake. There must be clear understanding between the parties about the terms and conditions of the contract. If the consent is obtained by coercion, undue influence, fraud, then there is no free consent. If the consent is not free, there will be no contract. Listen carefully, friends. If the consent is not free, there will be no contract. Next point is lawful object. Friends, the object must be legal. It not against the public policy. The object of an agreement is lawful unless it is forbidden by law. So, I will give one simple example to you. A, B, and C enter into an agreement for the division among them of gains acquired or to be acquired by them by fraud. The agreement is void as its object is unlawful. How they are acquired the gains? The gains are acquired by them by the way of fraud. So it is not lawful. So the agreement is void as its object is unlawful. An object is unlawful when it is a fraudulent activity or it is gain from fraudulent activity or illegal or immoral. Also, it is opposed to public policy or to imply injury to the person or property of another. Friends, next point is certainty. In the certainty, we will see about section 29 of the Contract Act 1872. It provides that an agreement, the meaning of which is not certain or capable of being made certain, are void. If the meaning is not certain, it can be a certainty or it can be a void. Thus, terms and conditions of the agreement must be certain and not vague or uncertain. So, the friends, we must have to clear about the object and certainty of the contract. Next point is possibility of performance. The conditions laid down in the agreement must be attainable and not impossible. As per the section 56, an agreement to do, an act impossible, it in itself is void. I will give an simple example to you. A agrees to pay B rupees 5,000 if B proves that two parallel lines meet each other. Now, this is established truth that two parallel lines never meet each other. Hence, the condition in the agreement is impossible to prove. Hence, it is a void contract. So, friends, when the contract is void, the possibility of performance as per the section 56 is to be considered. Next point is writing and registration. As per the Contract Act 1872, even oral promise has a legal recognition, but in certain cases there must be a writing and also be a registered contract. There are certain other legislations such as Indian Stamp Act, Transfer of Property Act, under which some agreements have to be registered, and this is the important point for the purpose of law and regulations. So, as per the Indian Contract Act 1872, any contract which is oral promise, it can be a oral or legal recognition for the oral representation or oral promise, but in certain cases there must be an agreement in writing and also it must be registered. And last point is not expressly declared void. Friends, in the section of 24 to 30 there are some points which are to be considered. Certain agreements have been declared to be void under these sections. Few of these agreements are agreement in restraint of trade. Second one is agreement in restraint of marriage. Third one is wagering agreements. Fourth one is agreement in restraint of legal proceeding, and last one is a contract made under a mistake of fact. So friends, this was the essential elements of a valid contract. So we will see in the next video. The next point is kinds of contract. Thank you.